Historical Society and the Court Historical Society welcome and thank you for attending this long overdue event to honor Justice Sanford. I didn't really know a lot about Justice Sanford. I'm quite a historian, and as we began to plan and prepare for this event, I was actually amazed at his career. Served as United States Assistant Attorney General. After that, he was appointed to the United States District Court, served in that lengthy capacity, and then, of course, served on the United States Supreme Court, where he made quite his mark. We have a really, I think it's an exciting agenda planned for you this evening. In addition to the lecture, we've got a chambers tour upstairs that you can participate in if you wish. Of course, we have some documents. We have the portraits, the commission. We have a photograph of his funeral, which I think is fascinating. And I would just like to point out his portrait painted by Lloyd Branson, a famous local Knoxville artist. We're opening an exhibit next week here at the East Tennessee History Center to honor him and to show off his artwork. And we've got some materials on that. We've got some materials in the back on both societies. And we just hope you find it to be a very interesting evening. With that, at this time, I'd like to turn it over to Chief Judge Thomas Varlin, who's going to introduce our speaker.
Thank you, Chuck, and certainly thank you for your service as president of our Eastern District of Tennessee Court Historical Society, as well as a board member for the East Tennessee Historical Society. As Chief Judge for the Eastern District, I'm proud to serve as honorary chair of the Court's Historical Society, and I appreciate the East Tennessee Historical Society for co-hosting this symposium, as well as providing the venue for today's event. I'm joined today by many of our Eastern District judges and other employees of the and staff of our and law clerks from our district court. I want to particularly recognize my co-district judge Pamela Reeves, our senior district judges Leon Jordan and Tom Phillips, Chief Bankruptcy Judge Marshall Parsons from Greenville, retired bankruptcy judge Richard Sayre, and our magistrate judges Bruce Guyton and Cliff Corker. Also with us today is our clerk of court, Debbie Poplin, and of course our executive director of our Court Historical Society, Don Ferguson. We certainly thank everyone for taking time from your schedule to be here for today's event. Just a brief background before we introduce our speaker. Our Court's Historical Society was formed in 1993 and adopted the mission of compiling and preserving the history of the United States District Court for the Eastern District of Tennessee. In addition to compiling oral histories and collecting artifacts relating to the court's history, we embarked, when Judge Collier was Chief Judge and Honorary Chair, on an effort to sponsor particular programs. We had an event in Chattanooga related to an historical case regarding redistricting of Chattanooga and Chattanooga politics, and in Greenville we had a panel discussion commemorating the 25th anniversary of the Hawkins County textbook case dealing with Bible being taught in public schools. So after some thought and consideration, as Chuck mentioned, we came up with the idea of a symposium centered around the life and times of Justice Edward T. Sanford, a former Eastern District of Tennessee judge who went on to become the only judge from East Tennessee to serve on the United States Supreme Court. And we're especially pleased today to have as our speaker Dr. John Shebb of the University of Tennessee. Dr. Shebb attended the University of Florida, receiving from that school a BA, MA, and PhD in political science. He joined the political science faculty at UT in 1982 and has been there ever since. From 2007 to 2014, he was head of the political science department, and I know he worked hard in that position because I was served on the political science advisory board at his request, and he did a great job. His area of specialization in political science is law, courts, and the judicial process. Professor Shebb has authored numerous articles in professional journals and is co-author of several books, including Government and Politics in Tennessee, Criminal Law and Procedure, Law, and the Administrative Process, An Introduction to the American Legal System, and American Constitutional Law. He's also a faculty fellow at the Howard H. Baker Jr. Center for Public Policy. And one of the books he's authored, and which led us to ask Dr. Shebb to be here today, during the state's bicentennial, he authored a book or pamphlet entitled 6 Tennesseans Who Sat on the United States Supreme Court. one of which, of course, was Justice Sanford. So that led us to talk to Dr. Shebb and entice him to come be our speaker at today's symposium. So it is my pleasure, on behalf of today's sponsors, to welcome Dr. Shebb, and please join me in giving him a round of applause.
Well, thank you, Judge Garland, and thank you for that warm welcome. Good evening, everyone. It's my pleasure to speak with you this evening about the only Knoxvillian to have served on the U.S. Supreme Court, Edward T. Sanford. When Judge Garland asked me to do this many months ago, I did not hesitate to say no. I could not say no to Judge Garland, given how good he has been to me and to my colleagues and our students in the political science department. But even had a stranger asked me, I probably would have said yes, because I like nothing more than talking about the U.S. Supreme Court. It's a bit of a hobby horse for me. As Judge Garland mentioned, 6 Tennesseans had served on the High Court, but only one was from Knoxville. Justice Sanford was also, as far as I know, and somebody may correct me if I'm wrong, but as far as I know, Justice Sanford was the only alumnus of the University of Tennessee to have ascended to the nation's highest judicial office. Now, I must begin with a confession. I'm not an historian. I'm a political scientist who, as Judge Garland indicated, studies the judicial process. Today, most of the scholarship in my area of inquiry is highly quantitative, and I guess I've done my share of statistical analysis of judicial decision-making. In fact, just this afternoon before coming over here, I was working on a data set. And that's a lot of what we do. But, over the years, I've become increasingly aware of just how important it is to understand history, to really understand what courts do and how they work in our political and constitutional system. So in conducting my research for this presentation, I happened upon a master's thesis written by a UT student, John McGuire, in 1990. The thesis was entitled, "The Supreme Court Justice from Knoxville, the Politics of Appointment of Justice Edward Terry Sanford." The project was supervised by 3 of the most illustrious professors ever to have been on the faculty at UT, certainly in my 33 years there. Milton Klein of the History Department, who was also the university historian, Bruce Wheeler of the History Department, and my own colleague in political science, Dr. Otis Stevens. So I would be remiss if I did not acknowledge those 3. They were fantastic colleagues. Well, Bruce still is, even though he's retired, he still hangs around. They were all tremendous to me and tremendous colleagues, and I appreciate them very much. Also, Mr. McGuire's thesis was extremely helpful to me in preparing these remarks, and so I want to give a shout out to him as well. So I have a few slides to show you tonight. Not as many as I was hoping, but a few anyway. The first slide is Knoxville in 1865, a scene from Fort Dickerson, which is, most of you probably know, I guess it was an artillery or lookout position on a ridge just across the river from downtown, and there's a park there now. And this photograph was taken from that vantage point in 1865, which is the final year of the Civil War, of course, and the year that Edward T. Sanford was born here in Knoxville. Edward's father, E.J. Sanford, had migrated from Connecticut in 1853 to seek his fortune here in Knoxville. In 1864, he established E.J. Sanford and Company, which was a pharmacy. And in 1872, his pharmacy merged with Chamberlain and Albers, which had been established by Knoxville businessmen Hiram Chamberlain and A.J. Albers to form Sanford, Chamberlain, and Albers. You see a slide or a photo of an ad for the company. And this company went on to be one of the largest and most successful pharmaceutical firms in the South. In the late 1880s, E.J. Sanford helped establish the Coal Creek Mining and Manufacturing Company, and in 1882 he helped organize the Mechanics National Bank. So I think it's safe to say that E.J. Sanford was certainly a member of Knoxville's business elite. One might even label him a tycoon. Edward's mother was Emma Chavans, the daughter of Swiss immigrants who settled in Fountain City and developed a successful farming business. E.J. Sanford and Emma Chavans had 8 children, 2 of which died in childhood as a result of a terrible cholera outbreak in Knoxville in 1864. Edward was the oldest child of the 6 who survived, being born a year after the cholera epidemic and just a few months after the end of the Civil War. Here's a photo of the Sanford family taken in August 1886, and Edward is the young man standing, resting his arms on the chair where his mother is sitting. Young Edward proved to be an excellent student, but in those days, opportunities for secondary education in Knoxville were pretty limited. So at age 14, he enrolled in the preparatory department of what was then called East Tennessee University, which of course was renamed University of Tennessee. In fact, that happened while he was a student there. Now, I'm not sure exactly when this photo was taken, but this is the hill with which most of us are familiar. I don't think any of those buildings exist today, but this is what the University of Tennessee looked like in the late 1800s. In 1883, at age 18, Edward Sanford graduated from UT with 2 degrees, a Bachelor of Arts and a Bachelor of Philosophy. By the way, that's a degree that UT no longer awards, and I'm not sure any institution awards that. But he received 2 baccalaureate degrees from UT. He then went off to Harvard, where he earned 3 degrees, another baccalaureate, a master's degree, and eventually a law degree. But prior to law school, he took a year off and went to Europe, where he, according to all the official sources, studied languages. One can only speculate what he might have been doing in Europe. But he came back and took his law degree at Harvard. And he was an excellent student, and indeed was appointed as student editor of the newly founded Harvard Law Review, which, of course, that's the preeminent law review in the United States. And to be the editor of the Law Review is certainly a very high honor. He was actually admitted to the practice of law while a student. Things were very different in those days in terms of how one gained admission to the bar. He was examined by the Honorable Horace Lurton, pictured here. At that time, Justice Lurton sat on the Tennessee Supreme Court. He would later go on to sit on the U.S. Court of Appeals for the Sixth Circuit, and he was another of the 6 Tennesseans who would eventually serve on the U.S. Supreme Court. The examination consisted of a discussion of a hypothetical case in which Justice Lurton supposedly did most of the talking. Now, having been raised in a household headed by a judge, I'm very familiar with that scenario. But I was amused that many years later, in reflecting on that bar examination, Justice Lurton, then retired from the Supreme Court, would remember this exam as the most severe and rigorous examination any man ever went through. Upon receiving his law degree in 1890, Edward Sanford returned to Knoxville, where he established his law practice. My UT colleague, Joe Jarrett, who has just penned a bio-sketch of Justice Sanford for the Knoxville Bar Association's magazine called Dicta, shared his sketch with me, and I thought that this quote was good. Jarrett observes that as a Harvard graduate, Sanford was something of a unicorn, attracting a large number of persons to the Knox County Courthouse to observe him in action. In 1891, Sanford married Ludy Mallory Woodruff, pictured here, the only photograph of her I could find, the only portrait of her I could find. Unfortunately, it was a very small image, and so blowing it up, it's pretty blurry. Obviously, this was taken when she was a young child. She was actually 25 when she married Edward Sanford. They had 2 children just born in the 2 years after they were married. Dorothy in 1891 and Anna McGee in 1892. In 1899, Sanford partnered with James A. Fowler, pictured here, the daughter, oh, excuse me, my bad. Yeah, I'm sorry, I don't have background information on Mr. Fowler, but there are people here who do, who know him. I do know, knowing a little bit about Tennessee political history, that Mr. Fowler would run unsuccessfully for governor and for U.S. senator, but he would serve a term as Knoxville's mayor, and later as a special assistant to the Attorney General under the Harding administration. Mr. Fowler would exercise considerable influence over Judge Sanford's appointment to the Supreme Court. In addition to being a prominent lawyer, Sanford was active in many educational, professional, and charitable organizations. He served as president of the UT Alumni Association and later served on the UT Board of Trustees. He also lectured at the UT College of Law from 1898 to 1907. Sanford was politically active and by the late 1890s was a leader of the Republican Party in Tennessee. In fact, he made what has been called the best speech of his career when he nominated his law partner, James A. Fowler, for governor at the 1898 Republican State Convention. In 1904, Sanford ran for governor himself. Neither he nor Fowler was successful in their gubernatorial campaigns, as the Democratic Party dominated state politics in Tennessee prior to the 1970s. But this political activity certainly made Sanford a well-known figure nationally, at least in Republican circles. In 1906, Sanford was appointed special assistant to the Attorney General of the United States. This happened due to the influence of James C. McReynolds, who was Assistant Attorney General at the time, and was another of the 6 Tennesseans who would go on to serve on the Supreme Court. McReynolds was a prominent Nashville lawyer before joining the Justice Department, and he had gotten to know Sanford over the years and was very impressed with his legal skills and wanted to recruit him into the Justice Department to assist in prosecuting what was called the Fertilizer Trust in the Southeast under the recently enacted Sherman Antitrust Act of 1890. In his capacity as a special assistant to the Attorney General, Sanford obtained indictments against 31 corporations and 25 individuals involved in this fertilizer trust. And this work led to him being recognized as being very skilled in litigation, and he was appointed Assistant Attorney General in 1907. And it was this individual who had a lot to do with that. President Teddy Roosevelt wrote a letter to Attorney General Charles Bonaparte saying, "I would not attempt, of course, to dictate any of your appointments, but I would be pleased to see a Southern man of the Sanford type named as one of your assistants." As Assistant Attorney General, Sanford served on the prosecution team. I found this fascinating. This is something I absolutely never heard of. The prosecution team in the only criminal trial ever conducted in the U.S. Supreme Court. That case was called United States versus Shipp. The defendant in the case was Hamilton County Sheriff Joseph F. Shipp. It was a prosecution for contempt of the Supreme Court. And this contempt occurred because Sheriff Shipp ignored an order allowing a man who was in the Hamilton County Jail and had been convicted, wrongfully convicted as it turns out, of a serious crime, a rape. He ignored the order and allowed a mob to come into the jail and take this inmate out and lynch him. And so the Supreme Court held him in contempt, but not without first having a trial. And it was Assistant Attorney General Sanford who actually conducted preliminary proceedings in the matter that were very important in obtaining the conviction of Sheriff Shipp. In 1908, President Roosevelt offered Sanford a judgeship on the United States District Court for the Middle and Eastern District of Tennessee. Sanford was initially reluctant, as he recalled in an interview in 1923, and I thought the quote was very good, and so I actually put the quote up on the screen. He said, "I did not want to go onto the bench, for I love the profession of the lawyer. I remember that one of the saddest days of my whole life was when I made my last argument before the Supreme Court in Washington, when I knew that I would never have again that most delightful of intellectual exercises. I hope that I shall always be called a lawyer in a profession that defends the weak and gives justice among men." Well, if he had any reservations, he apparently got over them pretty quickly and accepted an appointment to the United States District Court. And he was welcomed to the federal judiciary by Judge Horace Lurton, who was by then serving on the U.S. Court of Appeals in Cincinnati. And this is when Lurton wrote to Sanford saying, "Having admitted you to the bar through the severest examination any man ever went through, I now welcome you to the judiciary." And this very building in which we are located tonight, the old Customs House, served as the federal courthouse and also United States Post Office in those days. And later this evening, you will have an opportunity to see the courtroom where Judge Sanford presided from 1908 until 1923. It's a beautiful building, although I think it's fair to say that Judge Barvin and his colleagues occupy somewhat nicer digs across the street. As a district judge, Sanford gained a reputation as a thorough, cautious, and impartial jurist. His performance on the bench, as well as his extensive civic involvement, brought him to the attention of Chief Justice William Howard Taft, who, of course, is the only individual to have the distinction of having served both as President of the United States and Chief Justice of the United States. In 1922, Justice Malone Pitney resigned from the Supreme Court after suffering a stroke. And then Chief Justice Taft and Attorney General Harry M. Dougherty persuaded President Warren G. Harding to select Judge Sanford to fill the seat. Now, Sanford was not an obvious choice. For one thing, he was a district judge. Almost all of the federal judges who ascend to the Supreme Court come from the Court of Appeals. There are significant differences between the work of district courts, which are trial courts, and the courts of appeals, which are appellate bodies. And certainly the Supreme Court, as an appellate body, it's more like the Court of Appeals in terms of the way in which cases are decided. Moreover, there were more illustrious candidates for the job, such as Learned Hand, an eminent federal judge in New York, and Judge Benjamin Nathan Cardozo, who at that time was on the New York State Court of Appeals. Sanford was formally nominated by President Harding on January 24, 1923. In fact, right there is the commission, Judge Sanford's commission, his appointment to the U.S. Supreme Court. 5 days, this is the one thing I found most incredible in all my research. 5 days after he was nominated to the Supreme Court, he was confirmed by the Senate in a voice vote. No recorded votes. Believe it or not, most Supreme Court nominees were confirmed that way prior to the 1960s. In Sanford's case, there was no committee hearing before the Judiciary Committee. The nomination faced only token opposition, and he was sworn in on February 19, 1923, and joined an impressive group of justices, including Oliver Wendell Holmes here, and Louis D. Brandeis here, and really all of the judges on the court at that time were really quite impressive. And of course, seated in the middle is Chief Justice William Howard Taft, hence we call it the Taft Court. During Sanford's 8-year career on the Supreme Court, he wrote 130 opinions, including opinions of the court, concurrences, and dissents. He was closest, both personally and philosophically, to Chief Justice Taft. Sanford routinely voted with Taft and was one of several conservative justices that regularly met at the Chief Justice's house on Sunday afternoons for discussions and libations. In 1929, Justice Sanford authored the majority opinion in a case called Okanogan Indians versus United States, better known to legal historians as the pocket veto case. This decision upheld the long-standing presidential practice known as the pocket veto. Now, this occurs when a president fails to sign and return a bill to Congress within the constitutionally required 10-day period, and Congress adjourns before that 10-day period is up. Justice Sanford's opinion in the pocket veto case, I think, I went back and actually read it, it shows a very high level of judicial craftsmanship. It's careful, it is thorough, it is precise, all qualities that distinguish Judge Sanford during his service on the district court, and qualities that no doubt made him an excellent candidate for the Supreme Court. I think it's fair, however, to say that Justice Sanford's principal contribution to jurisprudence was in the field of the First Amendment, specifically the freedoms of speech, press, assembly, and association. So I'd like to take a few minutes to look at 3 First Amendment cases in which Justice Sanford wrote the opinion of the court. But before I do that, it's important to understand that during Justice Sanford's years on the court, the nation was experiencing a wave of political discontent that was really much more extreme than we are seeing today. In those days, of course, there were no social welfare programs, no workers' comp, no minimum wage law, no social security system, at least not at the federal level. There was no federal law supporting unionization or collective bargaining, and there was tremendous strife in the relationship between industrial workers and the companies for which they worked. And in this volatile atmosphere, a number of different left-wing groups agitated for reform, and the more radical ones even called for the overthrow of the government. And bear in mind that this is just a few years after the Bolshevik Revolution in Russia. And in fact, historians refer to this period from the end of the First World War up to the late 1920s as the first Red Scare. So it was really during the first Red Scare that Justice Sanford served on the Supreme Court. Now, during this period, Congress and many state legislatures enacted legislation to try to deal with this radicalism on the left. They enacted laws against sedition, laws against criminal anarchy, and even something called criminal syndicalism. Of course, prosecutions under these statutes raised serious constitutional concerns in that they limited First Amendment rights. In 1919, the Supreme Court had held that First Amendment rights could be limited when groups posed a clear and present danger to the national security. But by the time Justice Sanford joined the court in 1923, there was a minority, notably Justices Holmes and Brandeis, who argued that radical speech should be tolerated in a democratic society committed to a free marketplace of ideas. So, with that little background in mind, I'd like to take a look at 3 cases where Justice Sanford wrote the opinion of the court. The first is Gitlow versus New York, and pictured there is Benjamin Gitlow, who was the defendant in the case. Gitlow was a founding member of Communist Party USA, and he was arrested for distributing copies of a newspaper that he published. It was called Revolutionary Age, and this particular issue of the Revolutionary Age contained a left-wing manifesto that Gitlow had authored. And it was pretty standard fare, I guess, in that it called for the violent overthrow of the government, overthrow of capitalist society and all capitalist institutions, the establishment of socialism through the dictatorship of the proletariat, etc. This got him into serious trouble with the authorities in New York. He was convicted under New York's criminal anarchy law, which punished advocating the overthrow of the government by force. In order to be charged under the statute or liable under the statute, one did not need to act to overthrow the government, but merely to advocate it. Advocacy was the essence of the offense. At his trial, Gitlow argued that since there was no resulting action flowing from the publication of the manifesto, The statute penalized utterances without propensity to incitement of concrete action, and therefore was in violation of the First Amendment. The New York courts, though, decided that anyone who advocated the doctrine of violent revolution violated the law. Gitlow was convicted. He was sentenced to 5 to 10 years in prison, but he was released on bail while after the U.S. Supreme Court agreed to review his case. Unfortunately for Gitlow, the Supreme Court sided with the state of New York, and it was Justice Sanford who wrote the opinion for the court. But the main reason the Gitlow case is so important is that Sanford began his opinion with a very bold assertion. And that is, well, he simply wrote, "For present purposes, we may and do assume that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states." Now, that was a fairly radical notion itself in those days, because if you look at the text of the First Amendment, it begins saying Congress shall make no law respecting an establishment of religion, and it goes on from there. And in 1833, the Supreme Court had said that really all of the provisions of the Bill of Rights were enacted as limitations on the national government. And so if one had, if one believed that one's liberty, one's rights were being threatened by an action of the state or local government, one had to look to one's state constitution and to one's state courts for relief. Well, this was a classic First Amendment type case, but prior to the Gitlow case, the Supreme Court had never said that the protections of the First Amendment could be invoked against state action. And so that's the main significance of this opinion, that Justice Sanford comes right out and says, look, for present purposes, we're going to assume that, yes, indeed, all the protections of the First Amendment that relate to free speech and free press are enforceable against the states through the 14th Amendment. The 14th Amendment, by the way, was enacted after the Civil War, basically to protect the rights of the newly freed former slaves, but eventually it was expanded into a broad guarantee of liberty and equal protection of the law. By the way, when Justice Sanford made that bold statement in 1925, he was only talking about two provisions of the Bill of Rights, freedom of speech and freedom of the press. And as recently as 2010, the Supreme Court has continued to apply provisions of the Bill of Rights to the states. In a case out of Chicago called McDonald in 2010, the Supreme Court said that the right to keep and bear arms contained in the Second Amendment is applicable to state action under the 14th Amendment. So the process that really began with Justice Sanford's assertion is really not complete. There still are several other provisions of the Bill of Rights that have never been incorporated into the 14th Amendment. Now, this doctrine of incorporation had its roots in the late 19th century, but it really is a 20th century development. And Justice Sanford's opinion in the Gitlow case is widely cited as being very influential in pushing that doctrine. Now, given what I've said, you might think that Justice Sanford was about to deliver his own libertarian manifesto. No, that would not be the case. The Supreme Court actually ended up upholding Mr. Gitlow's conviction and the statute under which he was convicted. And here's what Justice Sanford said about that statute. He said, "A state may punish utterances endangering the foundations of organized government and threatening its overthrow by unlawful means. Freedom of speech in the press does not protect disturbances to the public peace or an attempt to subvert the government. A state may penalize utterances which openly advocate the overthrow of representative and constitutional forms of government by violence or other unlawful means." And I said it was a 7-2 decision. Justices Holmes and Brandeis dissented. They did not perceive a clear and present danger in the mere publication of the document, no matter how radical it was. In their view, the First Amendment clearly had been violated. But as I say, it was a 7-2 decision against Mr. Gitlow. And he was sent back to prison to finish his sentence when the Supreme Court made its decision. The second case is Whitney versus California, and pictured there is Charlotte Anita Whitney, who was the defendant in the case. She was a member of the Communist Labor Party of California. She was prosecuted under California's Criminal Syndicalism Act. The act prohibited advocating, teaching, or aiding in the commission of a crime, including terrorism as a means of accomplishing a change in industrial ownership or effecting any political change. One didn't have to engage in any sort of violent action or any action that had a real chance of undermining the government. One simply needed to advocate that or to be involved in an organization that was dedicated to that end in order to be subject to the statute. The essence of Ms. Whitney's offense was her effort in organizing a political party that called for the overthrow of capitalism, the capitalist state, and the establishment of communism through the dictatorship of the proletariat. The Communist Labor Party of California was not a democratic socialist party. Indeed, it was an offshoot from the Socialist Party that nominated Eugene V. Debs for president on many occasions. This was a radical offshoot of the Socialist Party. And it had close ties to the Soviet Union and certainly supported Marxist-Leninism. In a unanimous decision, even Justice Holmes and Brandeis went along with this one, the Supreme Court sustained Whitney's conviction and held that the act did not violate her First Amendment rights. And again, it was Justice Sanford writing for the court saying, the essence of the offense denounced by the act is combining with others in an association for the accomplishment of the desired ends through the advocacy and use of criminal and unlawful methods. It partakes of the nature of a criminal conspiracy, that such united and joint action involves even greater danger to the public peace and security than the isolated utterances and acts of individuals is clear. We cannot hold that, as here applied, the act is an unreasonable or arbitrary exercise of the police power of the state, unwarrantably infringing any right of free speech, assembly, or association. As I say, even Justices Holmes and Brandeis went along with the court's decision, although Brandeis did express some reservations in a concurring opinion. Interestingly, Anita Whitney never went to prison. After the Supreme Court made its decision of holding her conviction, the governor of California issued a pardon. And the final case is Fisk versus Kansas, also from 1927. Harold B. Fisk was an organizer for the industrial workers of the world, better known as the Wobblies. I couldn't find a picture of Mr. Fisk, but this is a photo taken at an IWW demonstration in the early 1920s. Fisk was indicted under Kansas's criminal syndicalism statute, which was very similar to the statute, the California statute under which Anita Whitney had been prosecuted. The indictment charged Fisk with knowingly and feloniously persuading, inducing, and securing certain persons to sign an application for membership in and issuing to them membership cards in the IWW. In other words, he was accused of organizing a labor union. He was tried, he was convicted, and sentenced to serve 1 to 10 years in state prison. And that conviction was upheld by the Supreme Court of Kansas. But in a unanimous decision, the Supreme Court reversed Mr. Fisk's conviction. Writing for the court, Justice Sanford concluded that the Syndicalism Act has been applied, in this case, to sustain the conviction of a defendant without any charge or evidence that the organization to which he secured members advocated any crime, violence, or other unlawful acts or methods as a means of effecting industrial or political changes or revolution. Thus applied, the act is an arbitrary and unreasonable exercise of the power of the state, unwarrantably infringing the liberty of the defendant. Now, note that the court did not strike down the syndicalism law per se. That would happen later in 1969, actually. But it did hold that the law had been unconstitutionally applied. This was the first time, at least the first time that I can find, where the Supreme Court reversed a conviction for unlawful advocacy on First Amendment grounds. So it really is a milestone in the development of civil liberties in the United States. Now, when we juxtapose the decisions and Justice Sanford's opinions in Whitney versus California and Fisk versus Kansas, I think it's fair to say that the Supreme Court was not simply some reactionary monstrosity bent on snuffing out all political dissent, which is what some of its critics at the time were, some of its left-wing critics at the time were saying. The court, and Justice Sanford in particular, was determined to separate what they regarded as legitimate political activism from what they perceived to be a clear and present danger to the constitutional system. Now, looking back at that first Red Scare, we may think that the country overreacted to the threat of communism, much in the way that we tend to view the McCarthy era today. But at the time, many enlightened and fair-minded people believed communism and affiliated radical left-wing activity to be a serious threat to the Republic. As I mentioned, Justice Sanford wrote many more opinions for the court, but I believe the ones I identified were the most significant. Surely he would have written many, many more opinions had fate not cut short his tenure on the Supreme Court. In March 1930, Justice Sanford developed uremic poisoning following a routine tooth extraction. He died unexpectedly in Washington, D.C. on March 8, 1930, the same day as his mentor, William Howard Taft, passed away. Justice Sanford was only 64 years old, which is pretty young for a Supreme Court justice. Who knows what he might have accomplished had he stayed on the court until age 90, as did his colleague Oliver Wendell Holmes. And certainly it would have made the struggle over the constitutionality of the New Deal that took place in the 1930s even more interesting, I think. This is a photo of Justice Sanford's grave at Greenwood Cemetery here in Knoxville. The funeral was held right down the street at St. John's Cathedral, and it was attended by the 7 surviving members of the court, which is the tradition in the Supreme Court for the justices all to attend the funeral of one of their colleagues. It was said to be one of the largest funerals ever held in Knoxville. Right over here is a picture that we were able to obtain from Greenwood Cemetery that shows a long line of cars winding their way through the cemetery on the way to the graveside ceremony. So what can we say about Edward T. Sanford's life and career? Well, in his master's thesis that I mentioned at the outset, John McGuire made the following observations that I think are very, very appropriate. One, Edward Terry Sanford was born into a family that provided him every financial and educational advantage. He did not, however, seek the easy way, but strove to do his best in all that he undertook. Second, he was in the forefront of his profession, taking positions of leadership in many organizations to which he belonged or for which he served. He was as industrious in carrying out the duties of these public service positions as he would have been had he been on salary. And third, he did not let his station or his personal views affect his judicial decisions. He brought the same zeal to the cause of the underdog that he did to the position of the wealthy. Now, this is high praise, to which I would only add that Justice Sanford, while perhaps overshadowed by others on the Supreme Court in the 1920s, was an exceptionally talented and well-qualified jurist who made an important contribution to American constitutional development. Certainly, we can all agree that Edward Terry Sanford did his hometown proud. Here's hoping he won't be the only Knoxvillian and the only UT alum to serve on the Supreme Court. Thanks for listening to my remarks.
Thank you, John. We'll hold this up here. That was extremely interesting, and I think deserves of another round of applause. It's fascinating. I turned around to Judge Reeves to think that down the street were 7 sitting members of the United States Supreme Court attending a funeral here in Knoxville. Amazing, as was the rest of the presentation. The Court Historical Society and the judges of the court have a small token of our appreciation for you to take and open up at your leisure. But again, we very much appreciate it. I know it took a lot of time and have to be here today, but I think you know why we honed in on Dr. Shedd to make the presentation today. It was very well informed.
Well, it's my pleasure. Thanks for having me.
Thank you so much. Just before Society providing for that reception. Just a couple of other words. As I noted at the beginning of the program, the Eastern District of Tennessee's Court Historical Society was formed in 1993 and adopted the mission of compiling and preserving the history of our court, and that's been very important to our judges, particularly our district judges, and all our judges, and our executive director, Don Ferguson. Let me ask our district judges, Judge Breeze, Judge George, Judge Phillips, and where's Don? Don Ferguson, just come up here for just a second. As many of you know, and many of you are members of our society, and particularly Don Ferguson, publishes newsletters of interest to the membership, compiled numerous oral histories, collected artifacts relating to the court's work, many of which are on display in each division. The headquarters of our historical display is just down the street here, is our historical suite, located in the entranceway to the Howard H. Baker Jr. Federal Courthouse. And found there is a permanent display of the court's history, including the Sanford portrait that we borrowed and brought over here today, items of historical value, written papers and memorabilia of judges, and much more. In other words, it's a treasure trove of historical items of significance that give great insight into our court's past, a snapshot of our court's present, and a precursor to our court's future. The historical suite is visited by members of the judiciary, practicing attorneys, and the public at large, including many school groups. In discussing our historical suite recently, the Eastern District judges, our district judges, had two thoughts. One was it's really more of a center than a suite. It's a focal point, it's a hub, it's a living history of our court that provides invaluable insight and education. The second thought we had was that our historical suite is really there because of the work and efforts of one Don Ferguson. And Don has a long list of formers to his name. A former member of Knoxville City Council, a former city editor of the Knoxville News Sentinel, former chief deputy clerk of the Eastern District of Tennessee. But none are more important, in our opinion, than his current title, and that is executive director of our Court Historical Society. So as we reflected as district judges on these two thoughts, our historical suite as a center and Don's tremendous contributions, we've come to this decision, which we've kept under wraps until today. And that is to recognize Don and his ongoing contributions and to express our heartfelt appreciation to Don. I'm pleased to announce that the district judges have voted to rename our history suite the Don K. Ferguson History Center. And Don, a couple of things. This is actually a replica. We have a larger embossed sign under production, but this sign, a larger embossed sign, will appear outside the History Center, the Don K. Ferguson History Center of our U.S. District Court. So I want to present this to you.
Well, thank you.
And where's Barbara? Where's Barbara? Barbara, come on up to the front. And we're also joined, Don now knows by many of his family. He snuck in.
Oh, my goodness.
His daughters, Donna and Julia, and their daughters, spouses, and so on and so forth. So we thank you all for being here and kind of keeping things quiet. I also, in addition to the sign out front, we've prepared a plaque that's going to hang inside the History Center. And this is the one, it's done. This will hang inside our History Center. And I want to read it very quickly. And we've also got a smaller sign, a duplicate of this plaque that we're going to present to you so you can take home with you. But this reads, the Don K. Ferguson History Center. And the History Center is named after Don K. Ferguson in recognition of his distinguished service and contributions to the Historical Society of the United States District Court for the Eastern District of Tennessee. Don has served as Executive Director and Newsletter Editor of the Historical Society since its establishment in 1993. Don also served as Chief Deputy Clerk for the Eastern District from 1974 until his retirement from that position in 2000. In 2015, the judges of the Eastern District named the History Suite the Don K. Ferguson History Center to recognize Don's service to the Historical Society and his knowledge of and appreciation for the collection and preservation of the history of the court. So Don, this is going to hang in the Don K. Ferguson History Center, but we'll let you hold it for now. It is a surprise, and I don't want to put you on the spot if you want to say a few words.
Well, I can say that it is an honor to work for these judges. I'm a former newspaperman, and I've been in the court as the deputy clerk, and I've always found it a great honor to be with the court. But of all the work that I've done in the past, I would have to say that I found the history work to be maybe the most rewarding, because I know that future generations will see the things that we have done, and many of you have contributed here with your oral histories, and I know that future generations will benefit from it, because I've benefited from the things that we've accumulated, that we've reviewed from the past, have been helpful to me from 100 years ago. And so when I do these things, I think maybe down the road somebody will see old Don's name and know that he's spent time listening to that future.
Well, now everyone that visits the center, both in the doorway as well as on the wall with the flag. But again, Don, I think I speak for all, not only the district judges, but all the judges in attendance and all the everyone associated with the court and the Court Historical Society, that we're it's just a small recognition of your many valued contributions. So,
well, you're very kind. And it was a real surprise, and especially my family being here. Barbara, you were surprised too, weren't you?
Say